The learning objectives for this course, Introduction to the New Mexico Pretrial System, are to learn the history and legal foundation of pretrial services in New Mexico, to gain an overview of the court system, and to understand the pretrial process and key decision-making points. Before learning about the legal foundation and the pretrial process as a whole, it's very important for you, as a pretrial services professional, to understand your role in the overall system. The role of pretrial services is to provide information to the court so that the court can make an informed release decision and to provide supervision and services ordered by the court. Pretrial services officers do this by conducting a pretrial investigation and risk assessment, making recommendations for release, and supervising individuals who are placed on pretrial supervision as ordered by the court. There are 7 courts that make up the New Mexico court system. You can find information on each of these courts in the link that's provided on this slide.
When we talk about pretrial justice, we have to keep in mind what part of the system we're talking about. During the pretrial phase of a case, defendants are accused of a crime but are innocent until proven guilty, meaning defendants cannot and should not be treated as if they are guilty. If there is a finding of guilt, accountability is applied via probation, jail, restitution, and rehabilitation. The goals of pretrial justice are to maximize release, to maximize public safety, and to maximize court appearance. In the world of pretrial, we call them the 3 M's, which you're going to hear more about in upcoming training sessions. So let's get into what is New Mexico's legal foundation. Pretrial justice really became a big attention and piece of focus in 2014 with a New Mexico Supreme Court opinion that came from, at the time, Chief Justice Daniels, in a case famously referred to as the Brown decision. In this Brown decision, it reminded us all that defendants who come into the system are all presumed releasable through our legal foundation. The Brown decision didn't change laws in New Mexico, but it rather reminded everyone of how bail means release, is supposed to work. Basically, it restated the law. It restated the law that all individuals charged with a crime shall be released, using least restrictive means, moving away from the use of money. Whenever possible, the court should release on personal recognizance, meaning with no conditions or minimal conditions. If not, the court must make specific findings, written findings, demonstrating that non-financial options are insufficient. The holdings of the Brown decision were that a judge cannot set bail or release and solely use money on the basis of a charged offense. Release decisions must be individualized, meaning defendants should not all have the same conditions. And if money is used for the purposes of court appearance, a judge cannot set an amount for the purposes of detaining a defendant or setting an amount that a defendant cannot afford. So what did this opinion do? Was it the catalyst of change to where we are now? Judicial leaders quickly realized if money could not be used to detain defendants who could potentially be a public safety risk to the community, then what could they do? They needed a tool. They needed some type of legal mechanism that did allow them to detain certain individuals who posed a risk to the community. So in 2017, after the approval of the legislature and voters, a thing called preventive detention was adopted. So what is preventive detention? In New Mexico, someone who is charged with a felony is eligible for preventive detention. Meaning, if the prosecutor files a motion to detain a defendant and provides clear and convincing evidence to a judge that no condition or set of conditions will reasonably assure public safety, then a judge can hold someone with no money, no conditions, just hold them. If the state does not prove beyond clear and convincing evidence that a person is a public safety risk, then the defendant must be released. Another change that came with the Brown opinion was the adoption of New Mexico Supreme Court pretrial release rules in 2017. These rules were meant to support our legal foundation in New Mexico. The rules provide judges and attorneys clear direction of how the system should work, timeframes things need to occur in to ensure individuals' constitutional rights of the accused are not violated. So for an example, the rules tell the judges what they must consider when making a release decision. It tells the judges and attorneys how much time you have for a case to remain in the system. The good news in all this is New Mexico was able to bring our pretrial justice system in line with both US and New Mexico constitutions, federal and New Mexico case law, and establish a legal foundation for pretrial justice in New Mexico. In addition, what you will learn about in later sessions is the vast majority of pretrial defendants are successful during the pretrial phase and do not miss court and remain arrest-free.
Pretrial release is the release of individuals who have not yet gone to trial. The New Mexico Constitution states that bail or release, bail equals release, may only be denied by a court of record pending trial for a defendant who is charged with felony charges, and only if a prosecutor requests a hearing and proves by clear and convincing evidence that no conditions will reasonably protect the safety of any other person or the community. This is known as preventative detention. If a request for preventative detention has not been filed, then it is presumed that that person is releasable, and the defendant by law should be ordered to the least restrictive conditions to ensure that they appear for all future court hearings and remain arrest-free. The New Mexico Constitution in Article 2, Section 13 also states that a person who is not a danger to the community and does not pose a risk of not showing up to court should be released and cannot be held in custody simply on a financial condition in which they cannot afford. Any financial condition set must be a reasonable amount. Remember, only defendants where preventative detention has been filed and found can be held pending trial.
For additional information on the bail laws in New Mexico, please review the Rules of Criminal Procedure 5-401.
Cases are initiated in courts one of two ways. The first is when law enforcement decides to cite and summons a defendant to appear in court for a new alleged crime. The defendant is released from law enforcement custody under the premise that they will appear in court at a later date. The second includes law enforcement's decision to arrest a defendant for an alleged new crime. If a defendant is arrested, they are booked into the local detention center, and the booking information is forwarded to the court to initiate the case. In our AOC pretrial sites, the Background Investigation and Public Safety Assessment Unit creates a case in the New Mexico Case Management System, Odyssey. That is followed by the completion of a Background Investigation Report, a BIR, and the Public Safety Assessment, the PSA. The BIR and PSA are made available to the judge to assist with conditions of release during the initial liberty hearing. The PSA is public record, so it is also available to the district attorney and defense counsel.
When someone is summoned or arrested and taken to a detention center, the court will schedule what is called an initial appearance hearing. This is typically in the form of an arraignment. If a defendant is in a local detention center, then that hearing should be held no later than 3 days after the defendant is taken into custody. If they are not in a local detention center, that hearing shall be held within no later than 5 days of the defendant being taken into custody. At this hearing, the defendant is notified of the charges they are being accused of and asked to make an initial plea. This plea can be in the form of guilty or not guilty.
As mentioned earlier in this session, defendants are innocent until proven guilty. Therefore, we cannot apply punitive punishing type strategies. We cannot treat them like they are guilty. The pretrial field has a ton of research that shows what works. What we've learned is minimal interactions with defendants produces good outcomes, while over supervision and applying punishments during pretrial supervision produces poor outcomes. Most defendants will make all scheduled court hearings and remain arrest-free during the pretrial stage. We also know from the vast amount of research we have that applying the same level of supervision in all defendants will also produce poor outcomes. We live by a motto in the world of pretrial, basically that says, the law tells us what we can do and evidence-based tells us what works. Pretrial supervision should be individualized based on a defendant's likelihood of returning to court and remaining arrest-free. We use what's called tiered level of supervision that ranges from possibly 1 check-in a month to 1 check-in a week. Most contact is now done remotely. You will learn the ins and outs of pretrial supervision in another training session, what strategies are used in pretrial supervision, understand the idea that less is actually more, and you will see data from across the country and New Mexico showing just how successful pretrial defendants actually are.
In the previous videos, we ran through the system from cite or arrest to case disposition. How is the system functioning? Is the public safe, and are defendants returning to court while their case is pending? These are just a couple of very important questions to ask and answer. The ability to provide data and feedback is crucial to examining the system and making changes if necessary. Change is difficult and can sometimes come with misperceptions and inaccurate information. Accurate data and measures can dispute false information and concerns that may not be based on facts. One example would be statements about how change is going to make the community unsafe and allow every defendant to be released. Pretrial data around the country has supported the improvements being made and shows that implementing the essential elements of a pretrial justice system and program improves public safety and court appearance. Your work as a pretrial justice partner and practitioner, especially in data entry, are crucial to confirming the legal and evidence-based practices that are being implemented in New Mexico.
Data metrics are a critical component of a high-functioning organization like the New Mexico Pretrial Justice Division. Data metrics show performance and success. For more information on performance and outcome measures, please see the National Institute of Corrections Measuring What Matters publication.